Hi, and welcome to More Human, More Resources, the HR podcast for entrepreneurs. I'm Vicki Brown, your host and CEO of Vidamaneo Enterprises. As a serial entrepreneur, I understand that having the right expert help has been critical to my success. That's why I'm dedicated to telling you, in plain language, what's going on in the world of HR that might impact your business and what you need to do about it, with real actionable tips to help you master that list of must-dos and grow your leadership muscle. First things first, the information contained in this podcast is provided for general purposes only and is not to be considered legal advice. Your decision to adopt or not adopt any practice or procedure mentioned in this podcast is solely yours, and we bear no responsibility for the outcome. We urge you to always consult legal counsel and other appropriate licensed professionals. And with that, let's get into the show. You're listening to Season 1, Episode 35. In this week's episode, our question of the day is, what is an inventions agreement, and do I need one? You may have a set of agreements as part of the new hire documents you want your employees to sign, things like a confidentiality agreement or an arbitration agreement. But you may not have considered an invention agreement. And while you don't have to have one, you might find that it's a good idea. Invention agreements, sometimes called invention assignment agreements, became really popular with the rise of Silicon Valley. Engineers and other technical experts were moving from company to company, and each of these tech giants, or wannabe tech giants, were creating applications, writing code, and innovating at the speed of light. So naturally, each company wanted to be sure that if their talent left their company, some groundbreaking innovative idea didn't walk out the door with them. Enter the invention agreement. This contract is designed to make sure that work or concepts that are in the sphere of the business, created during business hours, and with business equipment, are owned by the business. Basically, it's there to protect the company's intellectual property. Many times you'll hear the phrase work for hire. The work for hire doctrine basically says that work that can be copyrighted, including computer programs, belongs to the company, and the company assumes all the copyright and publishing rights. Work for hire only exists when an employee creates the work as part of their normal function in their job duties, or when an independent contractor is commissioned or engaged to produce a specific piece of work, and there's a signed agreement for the assignment. Now, as you might guess, copyright and patent law is complex, and this is a very broad overview by a non-lawyer. Also, the default rules for copyright and patent are very different, so for all these reasons, it's a good idea to have an invention agreement in place. The invention agreement with an employee specifically requires the employee to sign over all ownership rights to the company, because generally to the courts, without one, the employee's rights to ownership went out. So if Mary created an app before she started working for you, the invention agreement will clarify that Mary's pre-existing app belongs to Mary versus the company. Invention agreements generally have 3 sections: assignment, where the employee assigns all rights over to the company; the disclosure section, where the employee agrees to disclose any and all inventions to the employer; and the waiver section, where the employee can list works that are not part of the agreement, things like Mary's application. So yes, clarity is good. There's less room for confusion about ownership, and that cuts down on the possibility that there will be a disagreement. But there's another reason an invention agreement might be a good idea. Sometimes states have rules that impact work ownership as well. California, Delaware, Illinois, Kansas, Minnesota, North Carolina, and Washington have very similar guidelines on the subject. The California rule is basically that anything an employee works on entirely on their own time, using their own equipment, won't be subject to an invention agreement, meaning they will be owned by the employee, agreement or not. Now, at about this time, you're probably thinking, too complicated, I don't even need to think about this because it doesn't apply to me. Well, to that I would say, think about the intellectual property in your business. And I don't just mean applications or computer code. What about processes or systems you've devised that are proprietary to your business? What is special or secret to how you do what you do? Well, most likely, that's your intellectual property. Now, think about what you have in place to protect it. Ultimately, only you can decide if an invention agreement makes sense for your business or not. But if you decide to put one in place, remember, any agreement should be drafted by counsel because it needs to be legally binding. And the applicable laws around copyright and patents are very complex, so you'll need an expert to help you. If you found this information helpful, please leave a review and tell a friend. Thanks for spending the time. Until next week, same time, same place.